May I seek your lordship indulgence in mentioning part 2, item number 28 and 29. Lordship, although today is a fixed item, the leading counsel has some personal difficulties, so if the matter can be kindly taken up after 1 week.
28 with 29. You are for the appellant?
Yes, Lordship.
Appellant list. Yes.
Deeply obliged.
18 June.
May I seek your lordship's indulgence in mentioning item number 24 and 25, my lord, of hearing list. My lord, as there is a personal difficulty on conducting counsel of respondent number 5 to 7, if the matter may be taken up on a fixed date on 18 June.
You have informed other side?
Yes, my
you
lord,
have
I'm for the petitioner in item number 25 and I have no objection.
You have objection
No objection.
Oh, no objection.
For item number
on
25.
the prayer of learned counsel for respondent number 5 and 7,
5 to 7 in
5 to
item number
7.
24. Yes, my
and
lord.
with the consent of the petitioner's side. This is the matter again on when?
18th June, my lord, if possible.
18.
18, yes, my lord.
1/8.
1/8.
Okay. Okay. Yes.
And my lord, regarding item number 26, yeah, if the matter be taken up after 2 weeks. 26 of hearing list.
Why counsel is coming from outside?
Yes, my lord. They are still arranging counsel
Huh?
from they are still arranging counsel from outstation, but they have not finalized yet.
Prayer of counsel for the appellants list the matter. When?
After 3 weeks, if possible, my lord.
Okay, give a date up to 3 weeks.
2nd of July.
I'm obliged, my lord.
July.
Daily list for admission, item
2nd
number
of
1.
July, it will be vacation in Gauhati. So, if the councils are from Gauhati, they may not be. So, give it after the reopening of our vacation.
14 July.
I'm obliged.
My lord, this item number 34 of part 2 hearing list. Item number 34. This may come up after 2 weeks, my lord.
All right.
And for the appellant amicus.
Learned counsel for the appellant list the matter. Yeah, give a date.
23rd June.
Week of,
Daily list for admission, item number 1.
May it please your lordship. Your lordship, in this matter, I am appearing for the private respondent number 5. My lord, my lord, here the petitioner had challenged an order passed by the Metropolitan Magistrate Chennai in a criminal proceeding, my lord. So, on 13/1/2026, an order was passed whereby that aforesaid order, the impugned order, was stayed. So, we, as appellant, we filed a writ appeal, which is writ appeal number 1 of 2026. And the Honorable Division Bench of this Honorable Court, Your Lordship, on 25/2026, was pleased to allow our writ appeal, and the order was set aside. The order was of 13/1/2026, Your Lordship. If Your Lordship has the copy of the order,
Yes.
in page number 21, Your Lordship, operative portion, Your Lordship, in para number 65, Your Lordship. If I may read, Your Lordship, we have held that the writ petition, in so far as it seeks to assail the judicial order dated 3/3/2025, passed by 11 Metropolitan Magistrates Saidapat, Chennai, in criminal proceeding arising within the state of Tamil Nadu, is constitutionally not maintainable, Your Lordship, before this court, since the writ petition is pending on the file of the learned single judge, and a formal order would be required to be recorded therein. Let a copy of this judgment be placed before the learned single judge for passing appropriate consequential order in accordance with law, my lordship. My lord, as per the order of the division bench of this honorable court, my lord, appropriate order may be passed, my lord, dismissing this instant writ petition, my lord.
May I please, Your Lordship?
Just a moment. Interim order is dated
13/1/2026, your lordship.
Yes, who is for the petitioner?
Yes, Your Lordship. In this matter, Your Lordship, the petitioner is appearing personal.
Where from?
Your Lordship, today I seek your indulgence in making this mention for listing another date.
What remains?
Yes, Your Lordship. There is a pending related matters in these matters, Your Lordship. There is a related pending matters. It was also fixed on 9/11 along with this matter, Your Lordship.
If I may submit, Your Lordship, the division bench order of this honorable court, Your Lordship, it is very clear, Your Lordship, this writ petition is not at all maintainable, Your Lordship. It is very clear, Your Lordship. So
we
granting them.
are on the writ petition criminal 9 of 25.
Yes, Your Lordship.
Yes, Your Lordship.
That your CRP 2 of 2026, that's a different
That is
issue.
another
Yes,
matter,
Your
Your
Lordship,
Lordship.
but in the said order, it will be listed along with the CRP.
We'll take care of that. In view of the order, why should we keep unnecessarily drag on matters?
Your Lordship, may I? The petitioner is in hospital. That's why he cannot appear in person in today.
No, in this case, he is not appearing personally, is he? In the criminal petition?
No, my lord, he is not appearing in
Then-
person.
He is represented by counsel in this.
Yes.
Who is your senior?
The petitioner, Mr. Lasoirema, is also advocate, Your Lordship. I assist the petitioner, Your Lordship.
So you are the main person now, as far as the law is concerned. You don't have any senior to fall back upon. But let my senior come, please keep it pending. You are the expert advising the petitioner in person, isn't it? So give us any justifiable reason why we should keep this pending for another minute. Petitioner being in hospital is hardly a...
Your Lordship,
Matter
he
that
is
is
in
to be-
hospital for dialysis.
Yes, let him carry on with his dialysis. But we are on the law here. Yes, I think we have heard enough. And who you appear from?
Well, I am from respondent number 1 and 2.
Yes, heard. Mr. So and so.
Your Lordship,
It
may
does.
may we, this honorable court may be please to maybe given a time to the petitioner
What can he say?
on the date of 9/6/2026. Your Lordship.
If the expert cannot say why we should, how can the layman say? Petitioner in person. Because this is a question of law.
Your Lordship, the petitioner is always appear in person in this matter.
Just a moment, just one moment.
Yes. And he is also advocate, Your Lordship.
If I may, Your Lordship, make a submission. My
Yes.
Lord, the findings of the division bench are pretty clear, my Lord. It is not at all maintainable, Your Lordship.
No,
226
I am just on, because this line is there, that is why I was checking if there is any other prayer in the writ petition unconnected to this order of the magistrate.
My Lord, very good.
Because it says, paragraph 65 of the DB order, that insofar as it seeks to assail the judicial order dated 3/3/25.
My Lord.
That is why I am checking whether there is anything else in this writ petition. Apparently not,
Not, Your Lordship.
except for a direction that in future no magistrate shall act in such a way. Right?
Yes, Your Lordship.
Yes. Heard. Your name?
Lalthang Moya.
Yes, your name is shown as counsel. How can you keep saying he's petitioner in person?
Yes, Your Lordship, because he is my senior counsel. He is also advocate.
Have you filed power?
No, Your
Yes,
Lordship.
that is why your name is reflected in the cause list.
Yes, Your Lordship.
The petitioner may be an advocate by profession, but he is not here as petitioner in person. Kindly understand the difference. Or Mr. So and so. And so for. See, from the cause list names are there. Okay? By this writ petition has been preferred, challenging an order dated so and so. See from the first cause title. Okay. By order dated, what is the date of the stay order?
13/1/2026, Your Lordship.
13/1. Okay. By order dated 13/1/2026, the impugned order was stayed by this court. Full stop. The respondent, now who filed the appeal? Respondent number 5.
Yes, Your Lordship.
The respondent number 5 here in preferred writ appeal, being writ appeal number
1 of
1
2026.
of 2026 against the interim order of stay. Which came to be disposed of by judgment and order dated
25/2026.
yes, 20/05/2026, whereby the said order dated 13 that interim was set aside. Full stop. Further to that, it was held as follows. Paragraph 65 of this judgment WA. Para, in view of the above, the instant writ petition is dismissed as not maintainable.
May it please your lordship. Your lordship, my name is not reflected in the cause list. My name may have been reflected in the order. Your
Yes,
lordship.
what is
A
your
does.
name?
A does
A
for
does.
respondent number
does,
5.
respondent number 5. Okay.
Yes, sir. Oblige, your lordship.
Item number 2.
My lord, in the last court that my learned friend has submitted that he needs some time for filing objection, and I haven't received any objection from the respondents. Then I would like to submit that in the meantime.
No objection has been filed.
Your Lordship, regarding, we have not filed since because, like, Your Lordship, I think this can be disposed of without filing because regarding the maintainability, Your Lordship, I would like to we can make an argument on that and Your Lordship can decide. I don't think if Your Lordship says that we should file, then we'll file, but other than that,
What is this about? Let me just see.
yes.
My lord, there is pending IA. Let the IA be disposed of first.
What is the ground of your challenge to the order?
First of all,
Because my lord, because there is an order dated. There is an order dated 12/9/2022 in civil suit number 45 of 2014. My residential property is declared as the rightful and legal and rightful owner of the respondents herein. Then after the respondents herein had filed
Yes, we understand that. You are on a point of maintainability.
yes, Your Lordship.
Yes, what is that?
My lord, they have come under this FAO, they have come under order, if your lordship will see the nomenclature, they have come under order 41,
CPC.
Redwood, section 96. First of all, your lordship, if I take you to section 96, which is the annulment section. So, my lord, this appeal, this section 96, read with order 41.
From original decree.
Yes,
Yes.
original degree.
Yes.
So, my lord, now they have come against the order passing to execution. So, this is not the provision to come here, lordship. If I may just take you, lordship, to the history of the case, they've already come under section 96 order 41 earlier before this court. They've come for RFA and it has been dismissed by this honorable court. Now they have come again in the same section, impugning an order passing execution for attachment of a property. So this is not maintainable. Your lordship, they should come under order 43, appeals from order, if that is allowed. or otherwise they should have gone to review to the same court. So this is not the forum.
Why are you giving her free legal advice?
No free legal advice. So this is order 41 read with section 96 is for regular appeal in original decree. So it cannot pass through the door, Your Lordship. So they have not read the CPC properly, and it is not the way to come to court in order against the
What
order.
was the RFA against?
Against the judgment and all decree.
Okay, so that is dismissed.
Dismissed because it was condonation of delay was not condoned. Earlier, Your Lordship, if I may kindly apprise Your Lordship, civil suit 45 of 2014 was filed regarding the ownership of a property, and after many years of trial, in 2022, judgment and decree was passed by the trial court, wherein I was given the title to the property, and my learned friend's client, the appellant herein, was directed to vacate the property and give possession within 3 months. Then after, Your Lordship, they have approached the district judge. They have first approached the district judge, filing RFA and in the same provision, Order 41/296, before the district judge. And before the district judge, it was dismissed as withdrawn. Then, Your Lordship, we have filed an execution case for execution. Then, during long pendency of the execution case, they have come again to this court in RFA, again the same Order 41, Section 96, which was dismissed. Then the execution case carried on, and since it was not carried out, the executive court passed an order that for so long this judgment has not been carried out, you are not doing anything, you should vacate the property. Against that order, now again for the third time they are coming under Order 41/96 against the order passed in the execution for attachment, for vacating the premises. So this is not maintainable at all, Your Lordship.
Lordship,
What is section 17(2) of Mizoram Civil Codes Act?
That is
That has
the
also
That is
been
the
put
regular
up.
first appeal. Regular first
jurisdiction,
against judgment and decree.
jurisdiction of the court. Jurisdiction of the court. 17(2) of the Missouri Civil Code Act is regarding the jurisdiction of the court. Lordship, I would like to submit that what my learned friend had mentioned regarding the appeal which was being dismissed was regarding the appeal of order dated 12/9/2022 in civil suit number 45 of 2014, and this appeal is regarding this first appeal is regarding the order dated passed by the execution court dated 30/10/2025 was regarding the lock and key, and order dated 21 November 2025 was regarding the order of for possession.
So under 17(2) also it doesn't lie. That is also original suits.
That is the jurisdiction of the court, my lord.
That is jurisdiction with regard to appeals, where it will lie, whether before district judge or before the high court, depending on the pecuniary value of the suit.
Yes,
And
right,
that
my lord.
too, provided it's from an original suit in a civil proceeding.
Then, my lord,
This is not an original, so neither 17(2) covers you, neither section 96, neither order 41. Although you have not mentioned any rule, there are more than 30 rules in order 41.
Lordship, order 41 of CPC, Rule 5, there is stay by appellate court, stay of proceeding and of execution. Then it can be
First,
order
see what
41.
order 41 relates to.
Rule
See the
5.
heading. See the heading of order 41. Appeals
Yes,
from
appeal
original decrees.
decree. Yes, it is
Appeals
appeal
from original
decree.
decrees. So we need not even go to the rest of the rules.
But my lord, please look into order 41, Rule 5. The heading is stay of proceeding and of execution.
Your Lordship, they are not praying for any stay of execution. They are praying against stay of the order, which is a different thing. Proceedings in execution, this is a different thing, and impugn order is a different thing, Your Lordship. So, and they have never prayed for any stay of execution. They are just saying that this order is bad, and as Your Lordship has just suggested, this whole order is from original decrees, not order passed, interim order passed in execution. So the route here is totally wrong, Your Lordship. This, so either they have to withdraw or it has to be dismissed, Your Lordship.
My lord, we are praying for the,
See, if you go to Rule 5, you are on Rule 5, aren't you?
yes, my lord.
Yes. See, it says that an appeal shall not operate as a stay. Correct?
Yes,
Stay of proceedings under a decree or order appealed from, except as so far as the appellate court may order. Nor shall the execution of a decree be stayed, by reason only of an appeal having been preferred. But the appellate court may, for sufficient cause, order stay execution of such decree. That is meaning thereby that when an appeal against an original decree is preferred, its execution may also be stayed by the appellate court. First criteria is that it must be from an original decree. Please go back and have
Yes,
a look
sir.
at it in leisure. We are
Then, my
going to
lord.
dispose of this.
My lord, I would like to submit that in the meantime, we just want to redeem our we just want to redeem our LSC, which is in dispute of this case. Then we are paying out. The parties are having compromise settlement
That's up to you.
amounting to 50 rupees, and we are now as of today we are paying more than half of the
Go and tell that to
compromise.
the execution court. Ask it to recall its order saying we have paid, we have complied with the decree. Yes, heard so learned counsel for the appellant and Mr. Learned counsel for the respondent. This is a
My lord, if allowed, I will withdraw the case.
withdraw.
With liberty,
All
yeah.
right, very good. On the prayer of learned counsel for the appellant, the appeal stands dismissed as withdrawn.
Item number 3.
Lordship,
Yes.
I'm yet to file my rejoinder affidavit against the affidavit filed by the respondent number 1 to 5. So if I may begin, that's some further time to file my rejoinder affidavit.
Lordship, I'm appearing on behalf of my senior standing counsel for the respondent number 6. We also seek further time to file our counter affidavit.
You have filed rejoinder affidavit, no?
Not yet, my lord.
You want time for that?
Yes, my lord. I want to-
Yes. What about you?
Counter affidavit.
Huh?
Yes, Your Lordship, I'm representing respondent number 1 to 5, and I've already submitted my
All right.
affidavit.
Heard learned counsel for the petitioner who prays for further time to file rejoinder affidavit. Yes. Next.
Lordship, I'm appearing for
You're for?
respondent number 6.
Also heard learned counsel for the respondent number 6. Who? What do you want?
We seek further time to file our counter affidavit.
Huh?
Counter affidavit.
To file affidavit. Who seeks further time to file affidavit in opposition. Next. Who are you? For?
I'm appearing for 7 to respondent 7 to 36, my lord.
So and so
I have
appears
already
for
filed
respondent's number
7 to 36.
and
I have already filed, my lord. I have already filed my affidavit, my lord.
you are filing today.
No, I
No, Your Lordship, we have already filed our affidavit, except respondent number 6.
So that is where he wants to file the
Yes.
rejoinder. Okay, that okay. That is then understood since he is going to file rejoinder. You simply say appears for so and so, and you for, yes ma'am, you are for
1 to 5.
1 to 5. List the matter again on
19 June.
That's fine.
Obliged.
Item number 4.
Please, Lordship. Lordship, I'm appearing on behalf of my senior Mr. Joniel Tautsong, and as per his instruction, Lordship, we may be given another 2 weeks' time to file our additional affidavit.
additional affidavit.
Yes, Lordship.
Where is it required?
There is a huge gap between some days in the condonation of delay application, my lord. So in the previous court date, the Honorable Court had given us an opportunity to explain ourselves, my by way of filing additional affidavit.
Yes.
I'm appealing for the respondents, my lord. I had already filed my written objection. And
Yes.
upon perusal of my written objection, of late they came to this proposed additional affidavit. In view of the application in hand, my lord, they have failed to act diligently while pursuing the instant connected appeal and the application. There has arose 344 days of delay. And on merit, this is an appeal against acquittal. During the trial, there is no production of the SA at all.
Last that also you took time for that. I think you are just delaying the matter for no apparent reason. Okay, next Wednesday. By that you file whatever affidavit you want to file. Prayer of learned counsel for the petitioner. List the matter again on Wednesday, okay, in order to enable him to file additional affidavit.
10th of June.
Thanks.
Item number 5.
Similar prayer, my lord, in this item. Similar prayer in this item, my lord.
Similar prayer.
Yes. This is a very similar case.
All right. Similar.
The blue lights.
Item number 6.
Your Lordship, I have some personal difficulties today, so if this matter can be taken up after 2 weeks, my lord.
Where is it listed for others today?
The pleadings,
Something is to be done.
pleadings are complete, my lord. It's for condonation of delay, my lord. 667 days.
Okay.
It will require a bit of hearing.
All
from-
right. Heard learned counsel for the petitioner and learned counsel for the respondent. On the prayer of learned counsel, petitioner list the matter again on
After 2 weeks, my lord.
date after 2 weeks.
22nd June.
Obliged, my lord.
Item number 7.
Please, Your Lordship.
Yes.
This is a bail application under Section 483 BNSS. The petitioner is arrested on 31st 30/11/2025, Your Lordship. But however, Your Lordship, nothing was recovered from the petitioner, Your Lordship. In this case, 3.9 kgs was meth of contraband substance was recovered from the co-accused and the alleged from the vehicle, Your Lordship. In this connection, Your Lordship, the accused has never involved in this incident case. He was arrested on
CD is available? CD. Not available.
Yes, Your Lordship, it's not received yet.
And then how do
Your
you
Lordship,
proceed?
in annexure, there is also a charge sheet. Charge sheet is already annexed.
So it is already charge sheeted, so we should call for the TCR then.
Exactly, Your Lordship.
Scan copy of the TCR. Heard learned counsel for the petitioner. It appears that charge sheet has already been submitted in this case by CS number
SR number 16 of 2026.
dated.
Dated 1/12/2025.
Call for the scan copy of the TCR along with the CD. List again on
16 June.
We have annexed extracts of the case diary also. Today I opened my case diary in the office.
Item number 8.
Your Lordship, I'm appearing for respondent number 5, private respondent. My Lord, I think the appellants are absent.
What is the IA?
For condoning 396 days delay.
You have filed objection.
Yes, my Lord, I've already filed it.
How much? What is the delay?
396 days, my Lord.
None appears for the petitioner. Stroke appellant. Mr. So and so appears for respondent number 5. Objection has already been submitted on behalf of respondent number 5. Place the matter again on.
My Lord, if possible, 16th of June.
All right.
16 of June.
Not bad, my Lord.
Item number 9.
My Lord, as far as it's not, AD card has not returned from the respondent number 2 and 3. So if I may be allowed to take steps by way of justice in respect of the respondent number 2 and 3.
Heard learned counsel for the petitioner and counsel for respondents number
1. And my lord, I've already filed my objection.
1. Objection on behalf of respondent number 1 has already been submitted. However, as per office note dated 2/6/26, service in respect of respondent number 2 and 3 are still awaited. Learned counsel for the petitioner prays for effecting dusty service. Prayer is allowed. Affidavit of dusty service to be filed after completion of service. List the matter again on
4 weeks, my Lord, because they are
2nd of July.
obliged, my Lord.
Item number 10.
My lord, on behalf of Miss Larnett GA, since she's on her legs in another court, she's seeking 3 weeks' time for filing her objection.
None appears for the petitioner. Time is sought on behalf of respondent number
1 to 3.
1 to 3 to file objection. Accordingly, release the matter on 3 weeks.
25th June. Supplementary list item number 11.
Yes, Your Lordship, this bail application is handled by Miss Mary, and now she is in courtroom number 1, she is having hearing. So if this matter may be listed after tomorrow.
Okay, tomorrow.
My lord.
Learned PP who is handling this matter is on legs in another court, hence release the matter again tomorrow.
Hearing list item 27.
Lordships, my lords, I'm appearing as amicus in this matter. It's an appeal from the Special Court NDPS, my lords. Witness, my lords. Page 18 of the paper book. Lordships has it. My lords, I'll try to put the facts as concise as possible. Your lordships, this was the supposed independent seizure witness. Your lordships, if I may just read the witness's statement. I know the accused person, present before court today through video call. We are living in the same locality. I am Finance Secretary of Section B Branch YMA, Venglai Lungle. On 18th March 2021 at around 10:30, while I was on the road near Saikuti Hall to attend Sub-Headquarters YMA conference, I was called by my colleague Puvanlal Rema, Secretary Venglai Branch YMA, stating that the excise personnel requested us to witness the house search of P. Lal Engzawi of Venglai Section B. Lal Engzawi, my lords, is the appellant today. I went to the spot immediately and Puvanlal Rema, along with excise personnel, were already there. The excise personnel informed the present accused that her house is to be searched due to suspicion ground for keeping contraband drugs. Then we entered into her residence with the excise and checked her residence. Then we went to the room just above the store, which is used as a bedroom cum storeroom. There was a steel trunk locked with a padlock P. Mane, ASI of Excise, my lords, P. Mane, ASI is the seizing officer, asked for the key and they opened the said trunk in our presence. There were a few clothes and 24 soap cases inside the trunk containing orange color powder suspected to be heroin. Your lordships may mark the color of the seized items, my lords. Thereafter, my lords,
Yes.
Pimani ASI told us that weighing was also to be done, but as I have to attend sub headquarters YMA conference, I left the place of occurrence. So, my lords, this seizing witness did not actually see the weighing and the sealing of the said done. This para 4 makes it clear. Because ultimately, my lords, the only ground which I can raise here is to the doubt of credibility of the seizure.
Yes.
Yes, my lords. So, my lords, P. Mane ASI told us that weighing was also to be done, but I had to attend the conference. I left the place of occurrence. After attending the conference, I went to the residence of the seizing officer, P. Mane ASI, and she told me the weight of the seized article, but I do not remember the exact weight. I know that it was about 300 grams. I put my signature in the seizure memo at P. Mane's residence, who is the seizing officer. So, my lords, one thing is clear. When the seizure was done, he might have seen what was inside the trunk, but the weighing and the sealing, my lords, not part of that. My lords, in the cross, I'll just point out certain statements. If your lordships may take your lordships from para 3, serial number 3. Steel trunk was locked with padlock, but I do not remember who opened it with a key. I saw the seized article inside the steel trunk when they opened it, but I did not see who took out the seized article. Number 5. During my presence, seized article was not taken out from the steel trunk. I did not see when weighing, packing and sealing of seized article was done. My lords, my ultimate ground would be on this aspect. 7. During my presence, seizure and arrest memo were not prepared by the seizing officer. And I'll just my lords, I'll just read for the sake of completeness. I put my signature on a document at P. Mane's residence later on that day.
Yes.
During my presence, body search was not conducted on the accused, Laleng Zawi. The place of occurrence, storeroom cum bedroom of accused, was not easily accessible by the public. 11. At first, I do not know the amount of seized heroin, but I know it later from P. Mane, who is the seizing officer. 12. I was not present when they count the number of seized articles. I do not know the seized article were heroin or not, but it was suspected to be heroin. I saw the seized article packed in transparent polythene from the soap case hole, and I saw that the color was orange. So, my lords, an orange colored substance is what he has found. My lords, I'll take your lordships to the next page. Evidence is only of 4 prosecution witnesses, my lords. I'll stick to that. Page 20, my lords, is the second seizure witness, my lords. I'll start from serial number 1. I know the accused who is present in court today. At the relevant time, I was the secretary of YMA Lunglei. On 18th March at around 11:30 p.m., while I was near Lunglei police station, I received a phone call from ASI PC. My lords, I'm supposing this is a clerical error, PM, because the earlier statement was 10:30 a.m. in the morning. Just ASI PC Lalnei Thangi of Excise Lunglei requested me to witness search of the grocery shop residence of Ma Engi, present accused, at Labumpeng, Lunglei, and further requested me to bring other civilian. Then I called Lalnun Sangarentle, Finance Secretary, Section B, who is the other, my lord's, seizure witness, and informed the matter. Then I proceeded to the spot. On reaching the spot, ASI Lal Neithangi and party were already there along with the accused. Lal Nunsanga Rentle also came to the spot, who is the other seizure witness. In our presence, search of the shop come the residence was conducted. There was one big steel truck, I believe this should have been trunk, in the bedroom cum storeroom. There was a steel trunk locked with a padlock. Pimane, ASI of Excise, asked the accused to open the said trunk, but the accused refused and gave the key to Pimane of Excise. Pimane opened the said trunk in our presence. There were a few clothes and also some soap cases inside the trunk. The excise personnel took out the soap cases and it was 24 numbers. All the soap cases were opened and it contained pale orange color powder suspected to be heroin packed in transparent polythene. Weighing, packing and sealing were done on the spot by the excise in my presence. I put my signature in the seizure memo as seizure witness. The total of the seizure is 331.5 grams.
So which para of the cross? Chief appears to be okay.
I'm sorry, my lords.
Chief appears to be okay.
Chief appears to be okay, so far as this particular witness, my lords. But my lords, may I just mark one thing. I understand, my lords, there is a difference in AM, PM, that may be clerical. But this 11:30, my lords, I'm sure, my lords, this was done as per his knowledge. What he has stated in his chief, 11:30. Because the other seizure witnesses, 10:30. Because ultimately, my lords, this is the only doubt I feel which is in the credibility of the seizure. And my lords, your lordships may just come to page 21, which, my lords, your lordships may see serial number 6, wherein he was crossed to this effect also.
Okay.
Serial 6, page 21, your lordships. I do not know the exact time when seizure was conducted, but I thought that it was about 11:30 to 12 noon. My lords, I won't take your lordships to the other paragraphs. My lords. Now your lordships may come to the next, my lords, page, at page 22. My lords, this was the constable accompanying the seizing officer.
Witness number 1 again?
My lords,
Oh,
witness,
22. Huh?
yes, my lords. 22 is the constable
Who was the
present at the
first-
time of seizure, who accompanied the seizing officer.
This should be PW3.
PW3.
This is here in this is
Yes,
written
my lords.
witness number 1.
So, very good. It would have been 3,
Okay.
my lords. So, my lords, I'll take your lordships to the entire. I know the accused person who's produced before today. I am working as constable at Lunglei Excise Station since 2019. On 18 March 2021 at around 9:30, he says 9:30, while I was at Excise office on duty, ASIC Lal Neithangi received information that Lal Engzawi, who is the accused of Tlabum, possessed some contraband articles, and Pimane recorded the information. She also recorded grounds of belief, and I put my signature at excise office. She then directed me to accompany her with other constable. Before leaving the excise office, civilian witnesses from Venglai were informed and requested them to stand as witnesses. So, my lords, before they left, they had informed to stand as witnesses. They came. We then immediately proceeded to the place and reached there before the civilian witnesses have arrived. After the arrival of civilian witnesses, Pimane told the accused that she was suspected to possess contraband drugs and her house was to be searched. Then we searched the shop of accused, but nothing was recovered from her shop. We went to the upper room, which was used as a storeroom, cum bedroom, and search was conducted in the presence of witnesses. There was a steel trunk locked with a padlock. Pimane, ASI of Excise, asked for the key and the present accused gave the key. Pimane opened the said trunk in our presence. There were a few clothes and 24 soap cases inside the trunk containing orange color powder suspected to be heroin. One of the witnesses stated that he was engaged with other business and could not be present at the time of weighing, but the other civilian witness was present. Weighing, packing, and sealing were done on the spot during my presence. The total of the seizure is 331.5 grams. I put my signature in the seizure memo on the spot. As seizure witness, we proceeded to excise office along with the accused and the seized articles. So, my lords, here I just want to point out one thing, that, my lords, this person, my lords, who is not an independent witness, a constable accompanying the seizure officer, he bore witness to the apparent seizure of the drugs, my lords, up till its sealing.
Okay.
And now, my lords, in the cross at the next page, if your lordship sees para 16, I'll take your lordships to straight to what, my lords, what I think is relevant. Your lordships will see 16.
Yes. 10:30.
Search was completed around 10:30 a.m. My lords, it was completed. Quite contradictory to what PW1 and 2 said. PW1 said we are reached there and that he was called at 10:30.
Who PW?
1, my lords. PW1 says at around 10:30 I was called by my colleague and that excise personnel had requested us to witness the house seizure. And then, my lords, the PW number 2, the second seizure witness, says at around 11:30 a.m., though wrongly stated as PM, is when he got a phone call. Ultimately, my lords, my only case today is that I feel the seizure, the credibility of the seizure is wrong, is somewhat questionable.
All right.
My lords. Now, my lords, coming to the seizing officer witness, the evidence will be closed with this. I'll just show your lordships what had happened, inventory creation, and therefore it will be completed within 10 minutes. Your lordships may see page 24, who is the seizing officer. I know the accused who is present in the court today. I live in Venglai Lunglei with my family. The accused is my next door neighbor of the seizing officer. On 18th March 2021 at around 9:30 a.m., I received information from secret source that Lal Engzawi of Venglai Lunglei had just returned from Champhai and brought a large quantity of heroin from Champhai, which was supposed to be kept inside her residence. I reduced the said information into writing and immediately proceeded the said place with my party. On reaching the spot, I requested the nearby civilian to stand as witness. So, my lords, if your lordships would recall what the civilians had actually said, they received a phone call. Your lordships may not find it too material, but my lords, I'll come to that main part later. On reaching the spot, I requested the nearby civilian to stand as witnesses, but they refused. So I called 2 YMA leaders who attended conference at Saikuti Hall. On arrival of 2 civilian witnesses, I informed the present accused that search of her house was to be conducted on basis of information received by us. She requested us not to conduct search, but we declined. I also prepared grounds of belief under section 42 of the Act. In presence of civilian witnesses and accused, search of the house was conducted by me. There was steel trunk locked with padlock in the storeroom, bedroom, and directed the accused to open the said steel trunk. She refused and stated that she is scared to open it. She then gave me the key of the said trunk. When we opened the steel trunk, there were some soap cases with few clothes. Soap cases were taken out by me and we counted the said soap cases and it was 24 soap cases. All the soap cases contained suspected heroin. Weighing was also done. Total weight is 331.5 grams. During the process of weighing, one of the witnesses, Lalnun Sanga Rentle, who is PW number 1, my lords, went to attend sub headquarters conference and I told him to put his signature on the seizure memo afterwards. Packing and sealing was also done on the spot. I arrested the accused and seized the said contraband drugs along with the steel trunk. I prepared seizure and arrest memo on the spot. Lalnun Sanga Rentle, who is PW number 1, also put his signature in the memo, and then I brought the seized article along with the accused to excise station, and I submitted seizure and arrest report to OC on the same day. The seized article was kept in the excise malkhana. My lords, later on, your lordship to see that this malkhana register was also not produced. Because, my lords, and there was some time from when it was after inventory was created, that it was sent to the FSL for the FSL examination. And that part, my lords, your lordships, I'll put that out. I'll make my submissions there. Excise case number so and so was registered against the accused, and the case was endorsed to SISO Chuamliana for investigation. The accused was also sent for medical examination. Inventory, sample drawing, and other proceedings was done by the said IO. He received FSL report, and on the basis of investigation, he found a prima facie case under section 21C against the accused, and he submitted charge sheet. Unfortunately, case IO died of cancer just after he submitted charge sheet. I am working with the said officer for more than 10 years. Now, my lords, if your lordships just sees what was exhibited by the seizing officer, Exhibit P1, my lords, seizure, arrest memo, grounds of belief, information recorded by me, my lords, I don't see any irregularities there. Report of seizure and arrest, detailed particulars of accused. P6 is the inventory. I'll take your lordships to that page. 7 is the application for inventory, which is there, no issue. My lords. Is the list of sample drawn containing 3 pages. 10 is the charge sheet submitted, and M1 is seized articles. My lords, one thing I want to point out is, my lords, what your lordships would see is that when, my lords, packing is done and seizure is made, usually, my lords, the packets, a seal is embossed. And this is as per the standing orders of 1988-99, my lords, issued by the NCB. My lords, always cited in different judgments. I'll take your lordships to those judgments also. This, my lords, out here, one is the Malkhana register, which is not being exhibited. Though it may not be fatal, but, my lords, with the surrounding facts, it is what I'm trying to highlight here. Second is the seal, my lords. My lords, your lordships may also see at para 14 at the next page is the cross of the seizing officer. Your lordships has it. At para 16, at para 14, she says, as far as I know, search and seizure was completed at around 11 noon. The timing of the, my lord, seizure is all different for different witnesses. PW 1 and 2 might not have specified the exact time of seizure, but the constable who accompanied the seizing officer, there is a discrepancy there. Now, my lords, without taking your lordships through the evidence produced by me, by the defense, I'm just taking your lordships to the, my lords, inventory created at page 71. My lords, page 71 is the inventory. My lords, heroin, it was created the very same day, 331.5 grams. Mode of packing, packed in polythene, concealed inside 24 soap cases, further kept inside a steel trunk. Lordships has that?
Yes.
Yes,
Page, we are on DW1.
No, my lords. Page 71, my lords.
71.
Inventory, my lords. My lords, 71 is the inventory. Duty signed by the magistrate.
All right, I think since you have finished with the depositions, rest better you conduct in presence of PP, because again she will...
Yes. I have no objection.
She'll be at a disadvantage to again, we'll have to tell them which were the...
My lords, may I just point out one thing? If your lordship feels that it's because I'm appearing as amicus, Only difference I've seen is your lordships may see list of samples drawn at page 73. Your lordships may just have a look at this. If your lordship sees, there are 24 soap cases. From each soap case, 3 samples were extracted, each weighing about 50 grams, milligrams. And my lords, if your lordships looks at page 76, page
Yes.
76, I will not go into the time it took from the Malkhana all the way to the FSL when it was sent. But your lordships may see what has been received by the FSL. From serial number 1 to 24, your lordships will see, because in what was sample drawn was 3 samples, 50 milligrams each. It is not at all, my lords, consistent. It's not at all consistent with the samples drawn, the weight.
So 45, 50 and 45, that's what you want to point out.
45, your lordships may look at the next, my lords, 2, 92, the next 61, 48, 99, 40, 56. My lords, the chain of custody seems to be broken. So the whole credibility of the seizure, my lords, I'm questioning, my lords. All different numbers, my lords. 48, 79, my lords, it's more than what was the sample drawn. 92 at some point. Or else, my lords, the procedural insofar as grounds of arrest, the grounds of intimation, and that has been taken care of by the prosecutor. I'll continue, my lords.
You'll have to explain that. Yes, heard. Learned counsel for Mr. Suenso, learned amicus curiae for the appellant, and Suenso learned for the respondent. Hardil part list again on tomorrow.
Obliged.